There is a clock ticking right now at the United States Supreme Court. And when that clock hits zero, sometime between now and the end of June 2026, assault weapon bans in California, Illinois, New York, Maryland, New Jersey, Colorado, Virginia, and several other states could face the most serious legal threat they have ever seen. This is not a prediction. This is not political opinion. This is the documented reality of what is happening inside the Supreme Court of the United States right now, backed by SCOTUS blog, Bloomberg Law, the Duke Center for Firearms Law, the Constitution Center, and verified legal reporting from across the country. Stay with me, because by the end of this video, you will understand exactly what this 60-day clock means, why it exists, and what it could mean for every gun owner in America. To understand the 60-day clock, you have to understand the legal foundation that created it. Federal appeals courts in 2026 are still navigating a legal landscape that is coming into focus after the Supreme Court's game-changing 2022 decision in New York State Rifle and Pistol Association versus Bruen. That ruling found that in order to pass Second Amendment scrutiny, a law must be consistent with the nation's historical tradition of firearm regulation. That single sentence, consistent with the nation's historical tradition, has become the most consequential phrase in American gun law. Because here is the problem it created for states with assault weapons bans. There were no assault weapons in 1791 when the Second Amendment was ratified. There is no historical tradition of banning them. And that is exactly the argument gun rights groups have been hammering in courts across the country ever since. This Supreme Court term is already likely to be a blockbuster for the Second Amendment. It is the first time the Supreme Court has ever granted certiorari in more than one Second Amendment merits case in a single term. Those two cases, Woolford v. Lopez and United States v. Himani, have already been argued before the court, and decisions are expected before the term ends. These two rulings may come down at the end of term in June 2026, when the most controversial cases tend to be announced. That is your 60-day clock. By late June 2026, roughly 60 days from now, the Supreme Court will have issued rulings that will reshape the entire Second Amendment landscape for years to come. But Woolford and Himani are just the two cases already argued. Behind them, there is a massive backlog of assault weapons cases that the Supreme Court has been sitting on, relisting repeatedly without granting or denying review. The Supreme Court has repeatedly circled the question of AR-15 bans without quite pulling the trigger. Cases challenging Connecticut's post-Sandy Hook ban on assault weapons, including AR-15 style rifles and magazines holding more than 10 rounds, along with Viramontes v. Cook County challenging Illinois' ban and Duncan v. Bonta challenging California's magazine restrictions, are all pending before the court. The petitioners argue that if millions of Americans own a firearm for lawful purposes, banning it flips the Supreme Court's Second Amendment precedent on its head. As of the most recent tracking, Viramontes v. Cook County has been relisted 10 consecutive times, meaning the justices keep bringing it back to their private conference without granting or denying review. Legal analysts say that pattern is not nothing. It signals serious internal discussion among the justices. Snope v. Brown, which challenged Maryland's assault weapons restrictions, was relisted 13 times before the court declined to take it up, prompting Justice Brett Kavanaugh to write that the court should and presumably will address the AR-15 issue soon, in the next term or two. That statement from Justice Kavanaugh was written in June 2025. One term. We are now in that term, and the clock is running. The most important thing to understand right now is that multiple sitting Supreme Court justices have already gone on record about where they stand on assault weapons bans, and what they said should alarm every state that has one. Justice Clarence Thomas, in dissenting from the court's refusal to hear the Maryland assault weapons ban case, stated, "I cannot see how AR-15s fall outside the Second Amendment's protection. I would not wait to decide whether the government can ban the most popular rifle in America." Justice Kavanaugh indicated the court will likely address the AR-15 issue in the next term or two, signaling that the question is no longer whether SCOTUS will take up assault weapons bans, but when. And the Trump administration's Department of Justice has not been sitting on the sidelines either. The DOJ filed an amicus brief in the NRA-backed challenge to New Jersey's assault weapons ban, supporting the challenger's position. The DOJ has also directly sued the District of Columbia over its assault weapons ban. And the D.C. Court of Appeals, the district's own highest court, recently invalidated D.C.'s ban on large-capacity magazines, ruling that such devices are arms in common and ubiquitous use by law-abiding citizens across this country. That D.C. magazine ruling is critically important because it created something the Supreme Court pays close attention to, a direct split between courts. 5 federal circuits have upheld magazine bans. The D.C. court struck one down. That split increases the pressure on the Supreme Court to step in and settle the question once and for all. The Supreme Court will issue decisions in both Woolford v. Lopez and United States v. Hemani this term. These cases may provide some much-needed guidance for litigants and lower courts on how to apply the history and tradition framework to Second Amendment challenges. But they leave many significant issues concerning gun rights on the table, including the status of semi-automatic rifles like the AR-15, which is probably the most prominent unresolved Second Amendment issue. Here is why the Woolford and Hemani decisions matter even for the assault weapons question. There is a real chance that appeals courts will not make significant moves in gun cases until the second half of 2026, after the Supreme Court has rendered decisions in Woolford and Hemani. Legal experts note that usually there will be a lot of momentum to just wait and see, and once those decisions drop, the floodgates could open. The Third Circuit case challenging New Jersey's AR-15 ban might be the first final appellate decision to strike down an assault weapons ban, according to Andrew Willinger, Executive Director of the Duke Center for Firearms Law. That is because the court's balance has now tipped toward judges appointed by Republicans, with 2 new Trump appointees debuting during en banc oral arguments. Meanwhile, the states are not waiting around either. State assault weapons ban legislation continues to gain traction in various jurisdictions. Rhode Island's legislature is now looking to amend its ban in a way that would render the grandfathering that protected previously owned firearms useless, potentially making formerly lawful owners into felons. The amendment would flip the prior arrangement on its head, requiring those who lawfully possessed banned firearms prior to July 1, 2026, to sell or transfer them by the end of this year, or face criminal penalties for possessing them. Anti-gun states are moving fast, precisely because they know the 60-day clock is ticking and a Supreme Court ruling could change everything. Here is the complete picture as of April 2026. The Supreme Court has already heard arguments in Woolford v. Lopez and United States v. Hemani. A decision in Hemani will likely come down from the court by late June 2026. A decision in Woolford v. Lopez is also expected by late June 2026. Behind those 2 decided cases, 10 more assault weapons and magazine ban cases are sitting at the court waiting for action, including Viramontes v. Cook County on Illinois' AR-15 ban, Duncan v. Bonta on California's magazine restrictions, and the National Association for Gun Rights challenge to Connecticut's ban. The Second Amendment Foundation founder Alan Gottlieb confirmed his organization has almost 60 cases in federal court right now, defending Second Amendment rights percolating up to the Supreme Court, representing the most concentrated legal assault on gun control laws in American history. The 60-day clock is real. The cases are real. The justices have telegraphed their intentions in writing. And by late June 2026, when the Supreme Court issues its final decisions of this term, the legal map for assault weapon bans in America could look completely different than it does today. Subscribe to this channel. Share this video with every gun owner you know. Because what happens in that courtroom over the next 60 days will determine what millions of Americans are legally allowed to own for the next decade.